Welcome everybody to the organizational meeting of the Select Committee on Redistricting. We'll start with asking the clerk to take a silent roll call and determine presence of quorum. The clerk assures us that we have a quorum present here in person. So that takes care of the first order of business. The next order of business will be consideration by the committee of organizational motions. I don't know, they are on the, I think they're posted on the chamber automation system. Is that right, Bev? So I see I see a few members here don't have their surfaces. Does anybody want a paper copy of them? We have them in writing. Can we, Bev, let's go ahead and yep. Because I can look at the motions and discuss them as we take them up.
I just got up from a nap. I just all of a
Okay, let's go we're back on the record here, and I'll go ahead and recognize the senator from Brooke County to start with these motions, and we'll consider them one at a time, and happy to entertain any discussion or questions as we move forward. Senator from Brooke. I guess I turn your light on. Yes.
Thank you, Mr. Chairman. I move that the rules of the Senate be adopted to govern the committee in its deliberations.
Senator from Brooke County moves that the rules of the West Virginia Senate be adopted by this committee to govern the committee in its deliberations. Any discussion or questions? If not, all in favor of the motion say aye.
Aye.
Opposed? The ayes have it. That motion is adopted. Senator from Brooke.
Thank you, Mr. Chairman. I move that the committee be authorized to set an agenda of items to be considered by the committee.
Senator from Brooke County moves that the chair of the committee be authorized to set an agenda of items to be considered by the committee. Any questions or discussion? If not, all in favor of the motion say aye.
Aye.
Opposed? The ayes have it. That motion is adopted. Senator from Brooke County.
Thank you, Mr. Chairman. I move that the staff be authorized to, as needed, make any technical corrections to the bills, resolutions, and drafts which may be brought before the committee.
The senator from Brooke County moves that the committee staff be authorized to, as needed, make any technical corrections to bills, resolutions, and drafts which may be brought before the committee. Any discussion or questions regarding that motion? If not, all in favor of the motion, please say aye.
Aye.
Those opposed? The ayes have it. That motion is adopted. Senator from Brooke.
Thank you, Mr. Chairman. I move that the council be authorized to incorporate all bills or resolutions as well as any necessary technical changes into a committee substitute for the bill or resolution after the bill or resolution has been presented to the committee and the committee has voted to report the bill or resolution and to report it in lieu of the bill or resolution.
Question for the committee is the motion by the senator from Brooke that, I'll summarize it, that our council be authorized to roll measures into a committee substitute and report that to the floor in lieu of the bill or resolution. Any questions or discussion? If not, all in favor of the motion, please say aye.
Aye.
Opposed? The ayes have it. That motion is adopted. Senator from Brooke.
I move that any witness appearing before the committee, with the exception of Senate staff and elected officials, be administered the oath of office, the oath authorized by Senate Rule 28A.
Senator from Brooke County moves that any witnesses appearing before the committee accepting Senate staff and elected officials be administered the oath as contemplated by Rule 28A of the Senate. Any questions or discussions upon that motion? If not, all in favor of the motion, please say aye.
Aye.
Those opposed? The ayes have it. That motion is adopted. Senator from Brooke.
Thank you, Mr. Chairman. I move that due to the COVID-19 pandemic, any member of the committee shall be allowed to participate remotely in committee meetings and hearings as though they were physically present, that such members be counted as present in determining a quorum and shall vote on every question pursuant to Senate Rule 43. The chair shall provide for simultaneous video and audio participation among all members.
All right. So the senator from Brooke County moves that due to the COVID-19 pandemic, any member of this committee be allowed to participate remotely in committee meetings and hearings as though physically present, and that such members be counted as present in determining a quorum and shall vote on every question pursuant to Rule 43 of the Senate, and it will provide for simultaneous video and audio participation among all members. Any questions or discussion on that motion? If not, I'll put the question. All in favor of the motion, please say aye.
Aye.
Opposed? The ayes have it. That motion's adopted. Senator from Brooke.
Thank you, Mr. Chairman. I move that any member of the committee who wishes to propose any map or any amendment to any proposed map must do so as a strike and insert amendment with an accompanying maptitude file that includes a map of the entire state.
All right. The senator from Brooke County moves that any member of the committee who wishes to propose any map or amendment to any proposed map for this committee's consideration must do so as a strike and insert amendment with an accompanying maptitude file that includes a map of the entire state. Any questions or discussion? If not, all in favor of the motion, say aye.
Aye.
Opposed? The ayes have it. That motion is adopted. Senator from Brooke.
Thank you, Mr. Chairman. I move that the committee be permitted to consider all maps in a visual format as a PDF generated from Maptitude, which, once adopted by the committee, the accompanying legal description will be inserted into the bill itself.
All right. Senator from Brooke County moves that the committee be permitted to consider all maps in a visual format as PDF files that are generated from the Maptitude software, which once a map has been adopted by the committee, then the accompanying legal description would be inserted into a bill. Any discussion or questions on that? If not, all in favor of the motion, please say aye.
Aye.
Opposed? The ayes have it. Okay, Senator from Brooke.
Thank you, Mr. Chairman. I move that any member of the committee who wishes to submit any congressional or state senatorial district map for the committee's consideration, including but not limited to consideration as an amendment, must do so in accordance with the previously adopted Rule 7, at least 24 hours in advance of the meeting at which it may be considered, and staff will post the submission for public view and comment to the redistricting website as a proposed map or amendment by that senator.
All right. Senator from Brooke County moves that any member of the committee who wishes to submit any map, a congressional map or a state senatorial district map for the committee's consideration, including but not limited to consideration of it as an amendment, must do so in accordance with our previously adopted Rule 7 at least 24 hours in advance of the meeting at which it may be considered. And staff will post the submission for public view and comment to the redistricting website as a proposed map or amendment by that senator. Let me open that up for discussion or questions. If, with the indulgence of the committee, let me say that I think this is a really important piece of this. You know, we've all, I've heard all of us commit publicly to being open and transparent in this process, and I'm glad, I'm hoping that this rule is adopted, because what it'll mean is that before this committee acts or votes upon any particular map, it's going to be at least 24 hours, and I'm hoping we can do a little better than that if time permits, in everybody's possession so people can see it and so we can post it to the internet on our redistricting website, and then we can get feedback. You know, we'll get traditional feedback, we'll get phone calls and emails from our constituents, but they can also be able to provide, as they have, direct feedback to the legislature's redistricting website. And it's hard to do that if you can't see a map. So that's the idea behind this, and having stuff out there in advance for people to look at and think about and comment on before we take any action upon it. So again, any other comments or questions? If not, all in favor of the motion, please say aye.
Aye.
Opposed? The ayes have it. And so now, after, Bev, since we adopted, it was rule number 6, I believe, that authorizes members of the committee who are not here in person to join us remotely. I should note for our record that we have present a couple members of this committee who are not here in the room. Is that correct? And I believe the senator from Marion County has joined remotely. Is that right?
That's correct, Mr. Chairman. Thank you.
Senator Caputo, it's good to hear your voice.
I'm up in your neck of the woods, Mr. Chairman.
I'll send an alert to my constituents to keep an eye out for you.
Thank you.
Thank you. And Bev, is there anybody else who's joined us remotely? I think the senator from Preston joined us. Senator from Preston, can you hear us?
Yes, sir. I can hear you. Can you hear me?
We can. How are you?
I'm doing well. A little tired, but other than that, no worse for wear.
Well, we're glad to hear your voice, and we're glad that you could join and participate. Please give our regards to Terry. Do we have anybody else, Bev, who's on remotely? Wait a minute. That might obviate the need for the recess. See who. If that's the senator from Cabell who just joined us, Senator, you may be able to join us by pressing *6 to unmute yourself.
I'm here.
Glad to have you aboard, and welcome. And that means, I think, we've got virtually everybody. All right. The next order of business on the agenda for the committee is a presentation we're going to have now from our counsel on redistricting, constitutional criteria, other possible criteria. This can be fully interactive, and she's hoping to get peppered with lots of questions by members of the committee. But Ms. Shinzelors, I will turn the floor over to you.
Thank you, Mr. Chairman. Good afternoon, everyone. This is a general presentation on redistricting criteria. As you are aware, there are certain criteria that we must follow because they are derived from the U.S. Constitution or from federal law. Others are derived from the West Virginia Constitution, and we have to follow those. There are also some other possible redistricting considerations that we'll consider. And lastly, we're going to review the redistricting criteria adopted in the 2011 redistricting. The first criterion is population equality, and we'll discuss congressional districts first. On the left side of the screen, you will see some text from the Apportionment Clause of Article 1, Section 2 of the U.S. Constitution. The U.S. Supreme Court held in Westbury versus Sanders, a 1964 case, that this clause requires constitutional districts to be as nearly as practicable of equal population. That is, they are to be as close to perfect equality as possible. There's a corollary in our state constitution, which you'll see on the right side of the screen, Article 1, Section 4. And but the U.S. Constitution reads, representatives shall be apportioned among the several states which may be included within the Union according to their respective numbers. As I said, the U.S. Supreme Court has interpreted this to mean you have to get as close to perfect equality as possible. There isn't any fixed numerical or percentage population variance that is small enough to be considered de minimis or a bright line standard and to satisfy without question that standard imposed by the Constitution. As such, this principle permits only the limited population variances which are unavoidable despite a good faith effort to achieve population equality or for which justification is shown. And that comes from the Kirkpatrick versus Chrysler case from 1969. If it can be shown that a population variance could have been reduced or eliminated altogether by a good faith effort, the variance is unconstitutional unless it's necessary to achieve some legitimate state objective. On this slide, we see the authority for population equality for senatorial districts. It's a little bit different. For senatorial districts, it derives from the 14th Amendment, the Equal Protection Clause. No state shall deny to any person within its jurisdiction the equal protection of the laws. And again, you see the West Virginia corollary in our state constitution. In contrast, the Equal Protection Clause of the 14th Amendment requires state legislative districts to be substantially equal. This is a less stringent standard, which allows jurisdictions to deviate somewhat from perfect population equality to accommodate traditional districting objectives. And that language comes from even several cases, but Evenwell versus Abbott, a 2016 U.S. Supreme Court case. And Reynolds versus Sims, another case from 1964, states that so long as the divergences from a strict population standard are based on legitimate considerations incident to the effectuation of a rational state policy, some deviations from the equal population principle are constitutionally permissible with respect to the apportionment of seats in either or both of the two houses of a bicameral state legislature. Pursuant to this less stringent standard, jurisdictions are, again, permitted to deviate somewhat. The court has held that a maximum variance of less than 10% for state legislative districts is presumptively constitutional. However, a variance over 10% creates a prima facie case that it is presumptively unconstitutional and then must be justified by the state. Next, moving on past population equality, equal protection. We have the Equal Protection Clause again from the 14th Amendment of the U.S. Constitution and also the 15th Amendment of the Constitution on the right side of the screen. And I'll read that to you since we haven't covered that yet. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. In addition, we have the Voting Rights Act. Section 2 of the Act, which I've provided the site here on the left side, provides that no voting qualification or prerequisite to voting or standard practice, or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color, or in contravention of the guarantees set forth in Section 10303 F2 of this title as provided in subsection B, which refers to language minorities. Section 3 of the Act also is a function of, or it enforces the 14th and the 15th Amendment and authorizes the Attorney General or an aggrieved person to institute a proceeding under any statute to enforce the voting guarantees of the 14th or 14th Amendment or 15th Amendment in any state or political subdivision. Next, turning to requirements imposed by our state constitution, I've grouped these together as compactness, contiguity, and county lines because they are discussed in the same clauses. For congressional districts, Article 1, Section 4 of our state constitution provides that the state shall be divided into districts corresponding in number with the representatives to which it may be entitled, which districts shall be formed of contiguous counties and be compact. Article 6, Section 4 of the Constitution refers to the senatorial districts, which shall be compact, formed of contiguous territory, bounded by county lines, and, as nearly as practicable, equal in population, to be ascertained by the census of the United States. And I'll just go into detail a little bit about these criterion. These are not defined in our Constitution, compactness and contiguity. However, the U.S. Supreme Court has recognized compactness among other legislative policies, which, if consistently applied, might justify some variance, as previously discussed. On the other hand, drastic departures from compactness are a signal that something may be amiss. Evidence of compactness or lack thereof may shed light on potential violations. Contiguity is also not defined, and there are also several other possible redistricting considerations that I put here just for your consideration. These are criteria that have been adopted in various other states. Some are more traditional that have been recognized by the Supreme Court. Others are newer, such as the last bullet point that you see requiring proportional districts, which was adopted by the state of Ohio in their constitution more recently. And some of these will seem familiar because in 2011, the redistricting criteria that were adopted for the state senatorial districts in Chapter 1, Article 2, Section 1, Subsection C, which recognizes the primacy of the U.S. Constitution, where there's any conflict, and the equal population principle, sets forth a listing of other criteria that were considered in 2011. The U.S. Supreme Court has generally recognized that any number of consistently applied legislative policies might justify some variance, including, for instance, making districts compact, respecting municipal boundaries, preserving the cores of prior districts, and avoiding contests between incumbent representatives. In this instance, in 2011, you'll see there's a list of 5 redistricting criteria that recognize political subdivision lines in number 1, compactness in number 2, contiguousness in number 3. 4 and 5 establish a sort of balancing where county lines are crossed only when necessary to ensure that all senatorial districts were formed of contiguous territory or where adherence to county lines produced unacceptable population inequalities, and only to the extent necessary in order to maintain contiguity of territory and achieve acceptable equality of population. And number 5 also takes into account in crossing county lines to the extent feasible the community of interests of the people involved. Those are the redistricting criteria adopted in 2011. And that concludes my presentation. I'm happy to answer any questions.
Thank you very much, Liz. Let's open up for questions of council, members of the committee. Well, I have a question or a comment, really, and that is, if you look at, I guess it's number 8, page number 8 on this spreadsheet or PowerPoint presentation. And for our members who are attending remotely, I think this is on the chamber automation system. Is that right?
Correct.
I'm getting a nod. Let me ask Senator from Cabell or Marion or Preston if you're able to see any of that on the chamber automation system.
And council notes that this is not necessarily an all-inclusive list. There could be other criteria or considerations that have been adopted by other states.
Yeah, so we don't, we don't have to act upon any of these today, but I wanted to get them to everybody so that between now and the next time we meet, the criteria on page 7 are constitutional. We have to adhere to those. Substantially equal population, districts must be compact and formed of contiguous territory and bounded by county lines. And of course, there is a tension. Sometimes it's not possible to meet all the constitutional criteria. In other words, if we have to have districts that are equal in population, it'd be a 1 in a million chance where you could do that in West Virginia without, and do it by following county lines exclusively. So, but those are constitutional criteria to which we have to adhere. But the ones on the next page, page 8, are things that we can consider. And I guess what I would, if anybody wants to discuss any of them today, that's fine. We can have a discussion. I wasn't, planning to have a vote on any of these today, but I wanted to get them out there for members of this committee and other members of the legislature and the public who may want to weigh in. And some members of the public have already weighed in with us on some of these criteria, but perhaps at our next meeting, we could, after having thought about these and considered them, be in a position to decide which, if any, the committee might like to adopt and incorporate as for our purposes, our bill. So I'm advised that the senator from Preston County seeks recognition.
Thank you, Mr. Chairman. I would just let you know that, in fact, the chamber automation system does, in fact, contain the presentation, and I was able to access it.
Excellent. Oh, we can see you on screen now. You look great, by the way. Glad to see you looking good. Okay, and we'll make paper copies for any member of the committee who wants to take a paper copy with them of this presentation. But I guess between now and our next meeting, which is probably going to be a week from now, please think about these, because here's what happens. We're eventually, probably starting next week, going to begin looking at maps, which is different from what we're accustomed to here around this table and in the legislature generally. We're usually looking at bills that have words and text on the pages. But with this, we're going to work from maps, and the software will generate the text that draws the map, that makes the map. But in the bill, as counsel pointed out, and in the statute now that was enacted 10 years ago, drew the districts that we're all familiar with, that we've all run for office in. The bill traditionally will set out criteria. And it will include, if I have any say about it, all the constitutional criteria, but it can include such other criteria as this committee or the Senate, the legislature as a whole, decides we want to use in drawing maps. And I think it's important that we think about it, think carefully about it, because ultimately, if there are court challenges to our work product, you know, when we've enacted bills, I think one of the things the courts do is they look to see if the maps that we drew are faithful to the criteria that we said we were going to use in drawing the maps. And, you know, certainly the courts will consider whether we have adhered to the constitutional criteria. And, but I think it's important for us to decide before we really start drawing maps what criteria we want to use to try to meet with maps that we make. So I hope everybody will, during the next week or so, take some time to think about that, read through them. As Liz said, it's not an exhaustive list. But I'm happy to, you know, entertain any discussion of them now, maybe without a vote, if anybody wants to talk about any of them today. We've got time for it. We don't have much more formal business today. Anybody? If not, okay. Liz, did you have anything else you wanted to add?
Chairman, thank you.
All right. So on our agenda, the next item on our agenda is procedures for subsequent meetings. Here's what I think. Let me just throw one other thing out. And there hasn't been much discussion about this, but it's worth thinking about. And I'm not suggesting that we change this, but I'm suggesting we could, the legislature could, if it desired to do so. The Constitution makes no requirement on the number of members of the Senate, except it says that it can't be fewer than 12 districts. Right now we have 17 districts, which the Constitution requires 2 senators from each district. So I know that for the most part we think about this, we think about what the lines will look like if we're drawing again 17 districts. But it's not mandated by the Constitution that the number be set at 17. We could have 16 or 15 districts. The state had 15 until the early 20th century. It went to 16. And then after the decisions in Baker v. Carr and Reynolds v. Sims in 1964, which required the equality of population, in 1964, the legislature added the 17th district, which was an overlay district for Kanawha County. Historically, the Senate district that was the 8th was Kanawha County, and it included all of Kanawha County and nothing else. And but the legislature realized in 1964 that it was not compliant with the one-man, one-vote principle that had been recently espoused in the cases of Reynolds v. Sims. At that time, in 1964, I think Kanawha County had about 250,000 people in it, and it had 2 senators, and it had the same number of senators as the 2nd district, which was Marshall, Tyler, Doddridge, that area, which had about 70,000 people in it. And so there was an enormous disparity. And the legislature in 1964 created a 17th district. And it made it all Kanawha County, and it overlaid upon the 8th. So that Kanawha then had 4 senators. That stayed in place until the 2011 redistricting. And then there was a Kanawha-only district, the 17th, and the 8th district, which was the remainder of Kanawha County and part of Putnam County. Our colleague here in the committee is elected from the 8th. Anyway, I'm telling you more than I need to tell you this. the legislature would have the authority to decide to go to, 16 districts, 15 districts, 14, 18 districts, maybe 36 senators instead of 34. I'm not sure it would be a good look, given that the state has been losing population, for the legislature to respond to that by increasing the number of senators. But it's something that is within the authority of this legislature to examine and look at. So, that said, let's talk about subsequent meetings.
Mr. Chairman.
Yes, sir. Senator from Preston's recognized.
Thank you, Mr. Chairman. Did you say that the Constitution requires that each senatorial district have 2 senators, or is that also up to the decision by statute?
We are constrained in that by the West Virginia Constitution. It's Article 6, Section 4. And it says, for the election of senators, the state shall be divided into 12 senatorial districts. That was, of course, our 1872 Constitution, which number shall not be diminished. So I think we have to have at least 12 districts, but may be increased as hereinafter provided. Every district shall elect 2 senators, but where the district is composed of more than one county, both shall not be chosen from the same county. And then it goes on to say what Counselor Schindler has already shared with us. The districts have to be compact, formed of contiguous territory, bounded by county lines, and as nearly as practicable, equal in population, to be ascertained by the census of the United States. And then the Constitution says, and this is the mandate we're operating under now, after every such census, the legislature shall alter the senatorial districts as far as may be necessary to make them conform to the foregoing provisions. So we have to have 2 senators in each district. That's clear in the Constitution. We have to have at least 12 districts, but otherwise, I don't think we're limited by the Constitution in the number of districts. And of course, this is interesting for all of you who participated in all these public hearings we've had around the state and got some really good feedback from lots of citizens, a number of whom have said to us, why don't you do what other states have done and create an independent commission that will, do all this work? The Constitution addresses it. It's in Article 6, Section 4, and it says, after every such census, the legislature shall alter the senatorial districts. And so it places the duty and responsibility squarely on the legislature. In other words, in my opinion, it would not be constitutional in West Virginia without an amendment to the Constitution for us to pass a bill that created some independent commission to draw the districts and implement them. Anyway, that was down a slight rabbit hole. Senator from Preston, have a further question?
No, sir. Thank you, Mr. Chairman.
Thank you. So it may be something to think about. We are familiar with 17 districts because we all serve in, the citizens of the state who have sent us here from 17 districts. But it would be an option for this legislature to consider different configurations. Anybody else? Okay, procedures for subsequent meetings. That's the next item on the agenda. So I think our next meeting is going to be September 30th. It's 1 week from today. And at that meeting, I'm hoping that we'll start, getting to look at some maps. And under our rules, they'll have to have been submitted at least 24 hours in advance of that. And The sooner you can get them submitted, the sooner they can get posted, so the better, in my opinion. But just so members of the committee know, my expectation is that we all ought to just go ahead and block out Friday the 1st of October, Monday the 4th of October, Tuesday the 5th, Wednesday the 6th, Thursday the 7th, and Friday the 8th of October. I would not be surprised to see this committee meeting on every one of those days as we work through this process. And of course, we have interim meetings that are scheduled for the following weekend, the 9th and 10th and 11th, I think. And we'll meet throughout those. We'll have meetings. We can expect that this committee will meet during those interims. And of course, this could change, and it's actually up to the governor to decide. But my belief is the best information I've had is that the President of the Senate thinks that we will be called into a special session starting that following week to consider redistricting legislation and perhaps other legislation as well. I don't know what else the governor may be thinking about putting on a proclamation, but I would not be surprised if there are also, appropriations bills to be considered, that sort of thing. But I guess what I'm saying is the week before our special session, I think this committee could potentially be working every day. And we probably need to. And I'll also say this, we're not sure that the technology is going to allow members who are not here in person to see maps in the same detail that we'll be able to see them here when we start working with them. And so in-person attendance is going to be, even though it's not required under the rule we just adopted, it's going to be really important. I think it may be difficult to participate as fully and meaningfully remotely as you could in person. Now, I don't have in my mind any fixed idea of the order in which we are going to tackle these. Let me say it this way. There's a long tradition of deference and comity by one house to the other in this respect. Generally, the House of Delegates will take the first whack at a map of districts for the House of Delegates and send it to the Senate. It's like any other bill. Of course, it has to be passed by both houses and signed by the governor. But the Senate traditionally lets the House do that and send it to us for our examination. And then they do the same thing. They allow the Senate, they don't start to draw Senate maps in the Senate. They wait for us to send a map there that they have to consider and ultimately pass or not. And then I'm not aware of any particular tradition as to congressional districts. All that leads to this. I don't have fixed in my mind any firm idea, and I'm interested in the view of the committee on what you want to start on. Do you want to start on state senatorial districts, or do you want to start on congressional districts, or you want to try to consider both at the same time? Anybody want to weigh in on that? Senator from Putnam. Senator from the 4th.
Thank you, Mr. Chairman. Given that we're only doing 2 districts congressionally and potentially greater than 12 on the Senate districts and the technology involved, I would like to see us do congressional first and kind of go through what should be an easier process, I would expect, technologically that we're dealing with as we go through possible amendments and those things as well, and also to see the time frame it takes for those amendments to get through. with the Maptitude software. So I would suggest that we do the congressional districts first.
All right, that's one corner heard from. Anybody else? The other side of the river in Putnam County want to weigh in on that question? Anybody else? Any of our remote participants? Senator from Preston or Marion or?
Yeah, I would, thank you, Mr. Chairman. I would probably agree with the senator from Putnam as well that we should start with something easy just to test the waters.
Well, the senator from Preston is nothing if not optimistic. The choice of the word easy, I find to be very optimistic, and I'm grateful for your optimism. All right, well, I think maybe then we'll plan it that way, and of course, that could change. But having said that, so we've adopted a rule that requires when we convene next time, if we're going to be looking at any maps that any member of this committee wants us to look at for congressional districts, have to be in at least 24 hours in advance, and we'll post them up to the website. But I would encourage everybody, if you have a map that you think you're happy with and you think you can make one, and you don't have to wait till 24 hours before. We'll post them up for people to look at as we get them from members of the committee. And same with senatorial districts. If somebody wants to make a map that they think is the perfect map for how senatorial districts can be configured, and I think I would encourage you to consider go ahead and send it to us. Let's get it posted up, and we can start getting feedback, even if we're going to take a whack at congressional districts first. I think what I've learned through this public hearing process is that we will benefit the more public input we solicit and receive, the better we're going to be in what we produce. I really believe that, and I think the people. I'm thinking back to comments that I heard at a number of the public hearings. I think the people really want us to engage in that process, be open, be transparent, and be willing to hear from them as we consider, maps of congressional districts or Senate districts. Bev, Liz, what else? Am I forgetting anything else? Very good. The next meeting of this committee will be on September 30th at 3 o'clock p.m. right here in 208 West Wing in the Senate Judiciary Committee room. And these meetings, like all legislative meetings, are public meetings. We have some public attendance here, but not much. They're being streamed, live streamed, so citizens who want to watch and listen remotely are free to do so, but they're also free to come to the Capitol and watch in person. And we've got, 40 chairs? We got room to seat 30 or 40 people in this committee room. Further business. Senator from the 4th.
Just procedural question, see if you're looking this far ahead. Do you anticipate that the meetings that we go forward daily, starting on the 1st, are going to be afternoon meetings as well, or do you have any?
Don't know. That's a great question. We can, are you asking because you have a preference, or?
No, I'm asking for planning purposes. Just if we're going to start in the morning, go all day, we're going to start in the afternoon, keep 3 to 5, or if you have any concept of how that'll go.
Well, let's just say, let me
call it day by day.
And I realize that's unfair. It makes it hard for people to plan, particularly people who live close enough that they could be working or doing their normal lives. You know, let me just ask, the members of the committee have a preference on it? You know, for me, I would be traveling here from the Eastern Panhandle, so I could start at 9 and go all day. But, and if we need that, maybe we ought to do it. Senator from the 8th.
Mr. Chairman, thank you. Would it not vary from day to day based upon information that we receive from the other side of the chamber?
Well, that's a great question and point. I don't think we're going to receive any information from the House until we're in special session.
Okay.
And so and this is true for us as well. You know, we have, the committee's going to meet and work, but really in terms of formal consideration of a bill that could be passed or sent to the other house to look at from either house, that can't occur until we get into the special session, October 11th. So really, we're sort of working solo on our own here until we get to the start date of a special session. Senator from Brook.
Thank you, Mr. Chairman. Just thinking in terms of consistency as well as the 24-hour rule that we've adopted, that if we're at 3 p.m. on the 30th, given that we have that 24-hour rule in place, do we then have to keep it for 3 p.m. the following day? And just how that interoperates with how we're going to proceed. Just for
That's a good point. Okay, so let's say for now, it's a great question. Let's say for now we're going to just keep 3 p.m. as sort of a start time, and then you know, I guess if we have to, we can go into the evening. We've done that out here in the West Wing before. Sometimes we've been here till 1 or 2 in the morning, right? I don't know. We'll see. I guess a lot depends on, you know, whether or not it gets contentious and how complicated it gets, how well the software works for us, you know, throughout the process. But we'll say 3 p.m. on the 30th for sure, and probably let's just go ahead for planning purposes, say 3 p.m. On Friday, the 1st of October for sure. And then we can maybe be in a better position a week from now to map out what the following week looks like. All right. Anything else for the good of the order? Floor is open for any other business, any member. All right. If not, Chair recognizes the senator from Brooke County.
Mr. Chairman, I move that we adjourn.
Questions on adjournment? All in favor say aye. Aye. Opposed? The ayes have it. We are adjourned. Thank you, everybody.